after we got the deduction process, and now I'm like, where is all the chewing,
Okay.
noising? And
Okay.
it's the baseboards. The baseboards is ground zero. That's
All right. We're all in the baseboards.
baseboards.
But I mean, that's what you're saying.
Baseboards. Sorry. I'm just, sorry, Judge.
Before a single ruling is made, this case already feels unstable. We're walking into a landlord-tenant dispute where one side claims severe rodent infestation, rats, mice, droppings, chewed baseboards, while the other side insists the problem simply isn't there. And right away, you can feel the tension. This isn't just about rent or repairs. This is about credibility, about who the court believes, about whether someone is exaggerating or whether someone is being ignored. The defendant, Christopher, comes in visibly overwhelmed, talking about sleepless nights, health concerns, and what he believes is an infestation that's been dismissed. On the other side, the plaintiff has already taken steps the court ordered, an inspection, and they're about to rely heavily on that report. But here's the twist. Christopher claims the inspector has conflicts of interest, questions his credentials, and outright accuses him of lying under oath. That's a massive allegation in a courtroom. And hovering over all of this? Escrow. The one thing the judge made crystal clear last time. Rent money had to be deposited with the court, and it wasn't. That single failure may end up outweighing every single argument about rats, baseboards, and inspections. As this unfolds, pay attention to one key question. Is this a housing problem or a procedural failure that's about to derail the entire defense?
Pleasant Lake Park versus Christopher Janowak.
Good afternoon, Judge David Morris on behalf of Pleasant Lake Park, LLC.
Your name, sir?
Christopher Genovian.
Genoviak. Okay.
The W is a V.
Got it. All right.
I apologize the way I exited last encounter. I just a little bit of pain. It's my first time in court. I wasn't just wanted to get out of the Thunderdome. So, but Mr. Allen, good to see you again, Mr. Allen.
This is the Thunderdome?
I consider
we're gonna
when I'm sweating, it's a Thunderdome.
Oh, okay. Okay.
Which is about 98% of places I encounter.
I was gonna we could put something outside. The Thunderdome. All right. Okay, where are we on this case?
This is our third hearing on this case. Last hearing, the second hearing, court directed plaintiff to engage a critter control business to do an inspection of the premises.
Correct.
And directed that the defendant put November rent into escrow. Because of the timing, I drafted and have a signed unsworn declaration of the inspector that can produce to the court.
Okay. Yes. Have you seen it, sir?
I haven't seen it. I mean, I know,
okay.
I know what it may say, but.
Well, go ahead and look at it.
I'd rather hear your evaluation, but I'll read it. But this is quite a lot. I don't want to waste the court's time.
Well,
it's a lot of points.
I'm getting paid, so you're not wasting my time.
I may need to adjourn to call my attorney if that's free, and that's been referred to me for free by the state of Michigan. I may need to refer this. I may need to adjourn. I don't know. This is a lot. But I have prepared my statement.
Well,
which is brief and short.
Well, but hold on a second, sir. So I'm looking at this, and there were certain specific things that you complained about that were happening as a result of an infestation of some type. This is basically indicating that there is not or no evidence of an infestation.
So that's completely contradictory to the reality in which we live in. So I was interested to see I wanted to see what Mr. Weasel's inspector said, and to make this very clear, I think this is the most important part. Mr. Weasel, inspector, is my next door neighbor. He never provided a valid card. His company is not licensed or insured, and he hasn't proven that. He's my next door neighbor, and I believe there's a conflict of interest. Mr. Weasel owns a trailer park that the inspector lives in.
Accusing an inspector of conflict of interest, and worse, perjury, is not a small claim. In court, those words carry weight, but only if they're backed by proof. Christopher believes the inspector lives nearby, lacks proper credentials, and has a relationship with the landlord. From his perspective, this feels like the fox guarding the henhouse. Emotionally, that reaction makes sense. Legally, though, the standard is much higher. Courts rely on sworn statements under penalty of perjury unless there's concrete evidence to discredit them. The judge later explains this clearly. If courts dismissed reports simply because someone knows someone, the entire system would grind to a halt. That's an important legal principle. This is where frustration collides with procedure. Christopher feels unheard, so he escalates rhetorically, calling the report denial of reality. But courts don't operate on feelings. They operate on documentation, credentials, and sworn testimony. Viewers, here's the real question. Should courts require stricter independence for inspectors in landlord-tenant cases, or is this system the only way cases can move forward?
There's a major conflict of interest. This is the burglar investigating himself, essentially. And I'm satisfied with whatever you decide, of course, but there is rat poop in my living room, and Mr. Weasel. And
Hold on, sir.
Okay. There's a lot of
So why, I guess part of it, my question is, why didn't you put the money into escrow?
I just forgot. I'm looking for a job because I'm unemployed. I have the money. I can prove to you with bank statements that the money's there. I have over $3,000, almost $4,000 maybe, but the money's secure. It's there. I'll have.
Well, but hang on. It's got to be placed in court escrow.
Okay. I will.
Right.
It's my
And
first rodeo.
but I was kind of clear with you that you had to place that within 7 days of the last hearing, so it should have been in at the beginning of November.
Oh.
By November 7th.
That can be an escrow within by the end of the day. I was really just focusing on employment because I haven't been sleeping because there's a lot of rats and mouse. I spoke to Mr. Weasel this morning, and we both confirmed that we're going to do more inspections and maintenance. And that he confirmed to me that the baseboards in my kitchen are like flappy. And we didn't look for that because there was many holes around the skirting of the trailer. So that has been about almost completed, the skirting around my trailers.
Are you planning on hiring an expert to get this testimony?
I wasn't prepared for this denial of reality. So now I'm forced to call like Terminex. That's like a licensed and insured inspector, not a licensed. The gentleman that did this inspection.
I heard you.
Okay. The gentleman that did this inspection, like literally lives 2 houses down, and he doesn't own a car. His car used to say critter control on it, but it's gone. When I asked him where his car was, he said it's in the shop. The gentleman is very kind. We were all three of Mr. Weasel.
Oh, okay. All right.
We all witnessed poop in the house, and the poop is still there. There's still poop in my house. There's still holes in my kitchen and multiple places. The evidence is coming out of my ears. But I was not prepared for this denial of reality. I was expecting a deal, so we could all go back to living in peace and harmony. I was not expecting this to go on.
Well, have you called?
I'll call Terminex now.
No, hold on. Have you called? If you were expecting a deal, have you called the attorney's office to see about working something out?
I spoke to Mr. Weasel about making a deal multiple times in person and on the phone, and he just says he doesn't want to talk about it. But that was a few days ago. But when I talked to him this morning and complained about continuous rat poop and that the baseboards are now there is super evidence. There is chewing, and they're chewing on the rug in my second bedroom, and the carpeting. There's like carpeting all over my house.
Sir.
Yes,
I heard you the first time that you were here. I'm hearing you now. I understand that what you are saying is going on. That is why I asked plaintiff to get somebody in there to look at it, to provide something to the court with regard to what basically do an inspection to see if there's anything there.
Yes, Judge, there was an inspection done by Stephen Stamper, and frankly, to the point, to the allegation that there's some conflict of interest, I'm personally not aware of his living where he lives, but this statement submitted under the penalty of perjury by a a person who is qualified to do animal control, frankly, our court system would come to a halt if we just said that someone knows someone who did something and they made a sworn statement that this is a legitimate sworn statement. He will testify to the truth of these matters. He did an inspection of the outside and inside of the premises. There was no signs that and I spoke to him regarding this, he found no signs of ongoing animal activity. Really the primary purpose for this inspection was to look for something like a beaver or a bob under the premises. That he found one several-month-old animal dropping that he believes to be from a cat. He had done prior trapping events and really nothing. There is no ongoing animal activity under the premises. He found the condition inside the premises, which we believe to be, or he believes to be, a product of the tenant's living condition, is conducive to mice and rodent presence. He didn't find any specific evidence of current mice or small rodents, but he wouldn't be surprised if there are mice or small rodents that would be attracted. And it's the landlord's position that that attractive nuisance can be mitigated by the defendant, and any further work or trapping needs to be done in conjunction with cleaning the interior of the premises. So frankly, it's a large number of properties have mice and other rodents, and it's not surprising that he may see signs of a mice.
Michigan in the winter and there are mice indoors. What a concept. What?
So point number 17 is clearly perjury. I did not see any signs of ongoing animal activity inside the premises, period. That is completely false. And all three of us were there, and we witnessed poop in my northeast corner, and there's also poop underneath my stove, and we need to reevaluate the baseboards, and that will wash away.
All right, sir.
This delusion here.
Sir, how long is it going to take you to get Terminex out there, or whoever you're going to get out there, to give you your own?
So they said they would do on the website. It's like the next day for a free inspection, and then so I guess there's a free inspection the next day. But if there's going to be any kind of action, that's going to cost a whole lot of money. There's rents, and the things are in the vents. The baseboards right now, ground zero is the baseboards. That's all I'm complaining about. But specifically, number 17 is he's liable for perjury in that, and I may pursue him to go to prison.
You have at it. Okay.
Specifically 17.
Okay.
That's all. That's my first thing I look at.
You have at it.
Can I make one comment, Your Honor? Thank you. That Mr. Stamper took what he called an endoscope, which I believe to be a camera attached to a small tube,
yes,
and went in the heater vent because that was complained of. There was no findings in the heater vent.
I never complained about the heater vent.
There was also a purported hole in a cabinet under a kitchen sink that was inspected. So this moving target
This phrase, moving target, is devastating in court. What it means is that the complaint keeps changing. First it's large animals, then it's rodents, then it's baseboards, then vents, then carpets. Even if all of these concerns are real, the shifting focus creates a credibility issue. Judges need consistency. They need a clear problem, documented evidence, and a stable narrative. When complaints evolve mid-case, it looks less like discovery and more like uncertainty. And uncertainty favors the party that followed instructions, which, at this point, is the plaintiff. The judge isn't dismissing the possibility of rodents. He's signaling fatigue. Courts cannot relitigate a case every week based on new theories. That's why he draws a line here and pushes toward resolution. One more inspection, one more chance, and then trial if needed. This is the danger zone for defendants. Too much information, too emotionally delivered without procedural discipline starts working against them. Audience question: do you think Christopher is uncovering problems as he goes or losing focus under pressure?
I hear you, counsel. Because the last time we were here, we weren't really even dealing with, at least I didn't think, small rodents. We were talking about large
I made a point on that.
animals.
I made a point specifically because I knew you were going to comment on that. So with so we have done the deduction process. The skirting is complete, almost, I think, complete. Outside my house, there's 2 mouse boxes, and then he also bought me vent covers because there was holes in the vents. That's been completed. So we covered, and then after we got the deduction process, and now I'm like, where is all the chewing,
Okay,
noising?
okay.
It's the baseboards. The baseboards is ground zero. That's
All right,
normal.
we're all in the baseboards,
Baseboards.
but I mean, that's what you're saying.
Baseboards. Sorry. I'm just, sorry, Judge.
So plaintiff got their inspection. I am looking at that. That does not show any signs of anything that you complained of the first time. You are going to, although it seems it's a different thing now, irrespective of that, you are now going to get your own inspection. So my question is, how long is that going to take you to do? Because at some point, I'm getting this thing. We're going to try this thing.
Right.
I'm not going to listen to it every week without.
Yes, Judge.
Render a decision.
This is the judge reasserting authority, calmly, clearly, and firmly. He's not angry, but he is done with open-ended hearings. This is what judicial management looks like. The court gave instructions. The court ordered an inspection. The court required escrow. Now it's time to close the loop. By allowing Christopher to obtain his own inspection, the judge is preserving fairness. He's not siding with the landlord outright, but by setting a firm timeline, he's also protecting the court's time and ensuring the case progresses. Notice how this balances empathy and control. The judge acknowledges hearing everything. He even repeats details about the lake and wood line, proving attentiveness. But listening doesn't mean indulging indefinite delays. This is a masterclass in courtroom boundary setting. For viewers, this moment highlights why judges are less swayed by emotion than structure. Do you think the court gave Christopher enough opportunity, or should there have been stricter enforcement earlier?
Yes.
Go ahead.
Yes, Judge. I'm gonna go on the internet and I'm gonna contact Terminex. I'm gonna do a free inspection like as soon as I get home. And I mean, they may arrive today or tomorrow. I mean, probably tomorrow.
All right, great. If they arrive tomorrow, then I can put this off 1 week.
Yeah.
Got plaintiff's inspection, which doesn't show anything indicating what you were saying before, but now, admittedly, as plaintiff has said, that the target has changed, but now you get your inspection, and then we'll see exactly where we are.
The skirting, I'm not satisfied.
Okay.
Yeah, I mean,
and that's okay.
I don't want to be here forever, but I mean, my trailer is the closest to the wood line, and there's a lake. This is all.
I know you told me it's closest to a wood line. There's a lake. That's where I think the big beaver like thing came from before. Yeah, I know. I heard you. You know, people don't think I'm listening. I hear everything, even though I don't want to sometimes. I hear everything. So I'm going to adjourn this to November 21st, 2025. What time? 3 p.m. And the defendant, you're to do 2 things. I want that escrow paid, and you're to bring your inspection report.
This is non-negotiable. The judge doesn't ask. He orders. Escrow is now the price of staying in the fight. Without it, Christopher risks losing leverage entirely. Courts use escrow as a filtering mechanism. It separates genuine repair disputes from rent avoidance claims. By tying escrow payment and inspection report together, the judge is setting up the final showdown. Next hearing won't be about stories, it'll be about documents, reports, proof, compliance. This also protects the landlord. If the tenant ultimately loses, escrow ensures rent is already accounted for. If the tenant wins, escrow ensures the landlord doesn't benefit while conditions are unresolved. This is the legal system functioning exactly as designed. Structured, impartial, procedural. Audience engagement. If you were advising a tenant friend right now, what would you tell them to prioritize before the next court date?
Yes, Judge. Thank you, Judge. Thank you for your time.
All right. Thank you.
Thank you for your service.
You're welcome.
Judge.
Thank you, Counsel. That was much better than last time. That was okay.
This small comment says a lot. Courtroom demeanor matters. Judges notice tone, pacing, emotional control. Compared to the prior hearing, Christopher appears more contained, and that helps. But improvement doesn't erase procedural missteps. Courts don't expect perfection. They expect cooperation. Every time a litigant follows directions, credibility improves. Every time they don't, skepticism grows. This hearing was about resetting expectations. One final chance, one final inspection, one final compliance requirement. The underlying issue, rodents or no rodents, almost becomes secondary to process. And that's often how these cases are decided. Not on who's angrier, but on who followed instructions.
Okay. Well, for the rest of you, I'm all done. That's it. I can't take any more.
This case comes down to 3 pillars: compliance, credibility, and evidence. The court ordered escrow, missed. The court ordered an inspection, completed by the plaintiff. Now the defendant gets one final opportunity to present independent evidence and correct procedural failures. Judge Simpson maintained control, preserved fairness, and set clear boundaries. The outcome will hinge on whether Christopher delivers exactly what the court demanded, on time, properly, and documented. No more moving targets, no more delays. This is a textbook example of how landlord-tenant disputes can collapse under procedural mistakes, even when real concerns may exist. And it's a reminder that court is not just about truth, it's about proof. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.